Welcome to Module 2 of the Yurok Tribal Child Welfare and Behavioral Health Project. All right, foster parent training, stories from former foster parents, Allison McCovey and Fawn Canez.
I love our tribal youth. I love my little cousins. Growing up around kids, I've been the kid. I now know what important a lot of the adults in my life were besides my parents. I think the biggest thing was that this particular, my foster daughter, she, like I said, she was the same age as my younger daughter, and they had gone to preschool together. So I used to see her arrive at preschool, and it turned out that they were really close friends in preschool, and then they ran into each other during ceremony. And my daughter was like, I couldn't figure out why I knew this person, and then they finally put it all together, and they were so happy to see each other. So when that need came up, I had asked my daughter how she felt about it, and she was like, I definitely support it, and I think it is a good idea.
Helping just helping prepare for going to school, shopping for basic needs, and just enjoying family time. I know things that I took or I take for granted sometimes, just those what I consider normal family functions, like we're cooking together or baking together. I didn't realize that that was not something that my niece really had hands-on experience doing at home, and really appreciated. And it was just nice for us to have time to do stuff together. That was great. I think one of the biggest challenges in being a placement was I didn't feel like I had been fully prepared for all of the needs that came. And you know, when you do take in children who have, you know, experienced trauma and abuse, you know, they are gonna sometimes have their own unique challenges that you need to make sure to address and tend to. So when we got our foster placement, our relative place with us, I know that there was already like some medications and like a treatment plan that I didn't get all of the information in the first place. And so I definitely think that that was challenging in the beginning because we didn't feel like we were equipped, and we were trying to reach out. But luckily, there was a great team, the clinicians, the social worker who kind of came and rallied. I just wish it had been a little bit sooner, just because you know, when you have a child who has needs and you're not quite sure what to do, that's where it's really beneficial to have supports and people to really help kind of lift some of that load that you feel is all on your shoulders, which it's not. And so just knowing that whatever needs that a foster child may come to you with, that, you know, they're not the only one. It's not going to be like this is a new situation for other professionals or providers. So just being able to raise the flag when you do need those extras, because really there is supports that come along. And so just knowing now and looking back, I probably would have taken a little bit more parenting classes, even though I think I'm a good parent. Every kid has their own way of responding. And so just getting more tools for my bag.
Thank you, Allison and Fawn, for sharing some of your experience previously fostering youth. One of our kind of greatest systems of support really is each other, and sharing that wisdom, lending the support, and just, you know, sharing some tips or just having been there and done that. So thank you both for sharing that. All right, here we are in module 2, where in this module, we will review the Yurok Tribal Child Welfare and Behavioral Health Department's structure, purpose, policy, and services. So here we go. All right, so the Yurok tribe is a Title IV child welfare system, which means that the tribe must comply by the laws and regulations that were reviewed in Module 1. The system is governed by the Yurok Children's Code and the Yurok Title IV plan. As a federally funded Title IV agency, the Child Welfare Behavioral Health Department is required to collect and report its dependency data to the California Department of Social Services, who will pass it on to the Administration for Children and Families, which is a federal organization. All right, so Yurok jurisdiction and service area in child welfare. The Yurok Tribal Court has 4E jurisdiction over the following. So all Yurok tribal members and their children, and all territory within the Yurok Reservation. The Title IV service area is Humboldt and Del Norte counties, and a child must have a Yurok parent and be determined eligible for Title IV services. Placement. So there are various types of placement, which we will cover in more detail throughout this module. Those are inclusive of voluntary family maintenance, court family maintenance, family reunification, permanency planning, and extended foster care within the Yurok tribal court system. So here you can see a flow chart of sorts, which kind of details those various types of placements and scenarios. So you see over here, we'll start here on the far upper left. So there are a couple different ways which there can be intervention to support a child or children and their family without removal. So without removing the child from the home. And there are a couple different ways that that can be done. So this is again where there is no removal. There are some stressors, some issues, some safety concerns that have been identified through an investigation process. And in the event it is determined that those concerns meet a certain threshold or level where there is some intervention that would be beneficial or required, the child can remain in the home in either a voluntary family maintenance or a court family maintenance scenario. So we will go over this in more detail, but just so you can see, a voluntary family maintenance situation has no court intervention. So there's no going before the judge, but there is a case plan which identifies different actions, goals, services to support the child remaining safely in the home. Now, there's also what is called court family maintenance. So this is where the situation goes before the court, goes before the judge in initial hearing. And then similarly, a case plan is developed that identifies different services and supports so that the child can safely remain in the home, but with some court oversight and intervention. And that will get monitored through a subsequent series of hearings. Now, in the event that through the investigation, it reveals that the child needs to be removed because of more extreme safety issues, then the process goes into family reunification, which will go before the court. Similarly, there will be a case plan developed and a subsequent series of court hearings that are extended over a period of time to monitor the situation with the goal that the child will ultimately return home to their parents. A lot more involved in that. We'll go over that in a bit more detail, but you can just see here kind of, a flow chart of sorts of that process. All right, so back to voluntary family maintenance. So this is where the family essentially agrees to engage in non-court ordered services, right? So again, it doesn't go before the court, it doesn't go before the judge, but there have been some challenges that have been identified, and the family agrees to engage in whatever services and supports are identified in team with the department in order to help support that child remaining safely in the home. So while it is labeled voluntary, it's kind of a little bit misleading in that it's kind of like voluntary or else. I mean, I hate to say it that way, but really it's like if we don't engage in this voluntary kind of support process, then it is likely that future court involvement may be, where the trajectory kind of leads us. So this is, again, voluntary, but there is a certain level of, consequences if the family doesn't engage in whatever identified services and supports that are determined with the family in collaboration with the department. So family maintenance. This provides protective services to families to keep children in the home. So maintaining the family unit, maintaining the child in the home. Services can be really varied depending on, the unique situation and circumstances of that child and that family and what led them into, the situation where the child welfare department is, concerned. Those services could include anything ranging from mental health, housing supportive services, in-home support. So having, some kind of hands-on in the home services to kind of mitigate any safety concerns. It could be involving substance abuse treatment, domestic violence intervention, and or parenting education. Again, really unique to whatever led the family to be involved in the child welfare system. So you see here below the excerpt of the flow chart that pertains to family maintenance. So this is where there is some court involvement and oversight. Although the child is remaining in the home, there is an initial hearing. So it goes before the court, goes before the judge, and then a case plan is developed that may include any number of these types of services, depending on what the family might need and what might be beneficial. And then there is subsequent review of their progress through subsequent hearings, and we will talk more about those. All right, family reunification. So this is where the child or children have been removed from the parent or parents, have been removed from the home. So these are time-limited services to help reunify the family. So time-limited meaning there are, anywhere from like 6 to 12 to 18 months, maybe even more, for the family, the parents, to be able to resolve whatever those safety issues and concerns are, to ideally have the child or children return back to the home and their care. It's time limited because, there has to be, some kind of, it can't go on forever, but those time limitations are also federally required and required by the state as well, which is, the funding agent. So family reunification, again, children are removed. The situation goes before the court in what's called a detention hearing. So that's after the children have been detained. Again, case plan to reunify the family, which may include anything ranging similarly, substance abuse disorder treatment to resolve those issues, mental health services and supports, housing or employment type goals, cultural goals, and perhaps some parenting support or education as well. So these go, once it is determined that indeed the best situation is for the children to remain out of the home of their parents, whatever those allegations were warranted, at least in part. And then there is a process of subsequent court hearings to not only monitor the case, but also, kind of have intermittent opportunities to kind of see and experience the progress, as well as make plans in the event that reunification is unsuccessful and there needs to be an alternative plan for the child. So that could be anything ranging from a guardianship or adoption, or the child to remain in extended foster care, or best case scenario, the child returns home and the case is closed. All right, permanency planning. So to ensure children can grow up in a permanent, safe, and secure living arrangement is the goal of permanency planning. So this is basically when or if reunification is unsuccessful, the social worker and department is making kind of subsequent plans for what will happen with the child in a longer term basis in the event reunification is unsuccessful. So alternatives to reunification include guardianship, adoption, and extended foster care. And this type of decision about what that permanent plan is happens towards the tail end of that, kind of timeline of the time limited reunification. So there are permanency hearings, perhaps maybe 18, 24 months in after the children were detained to make the decision about what is the best permanent plan. And of course, who that is going to be with. Now, most oftentimes it is with the individual or individuals that the child has already been with for some amount of time. But that's not always the case. Maybe the permanent plan is with, say a relative, who lives, out of the region or whatever. But the plan is happening kind of throughout and leading up to the process of failed reunification. All right, permanency planning. So Yurok guardianship. This is where parental rights are not terminated. So it does not sever the legal relationship between parent and child, biological parent and child. Now, in a guardianship, the parent can petition to regain custody. So let's say reunification has been unsuccessful. The court orders the permanent plan of guardianship with, let's say, a relative. Now, maybe fast forward 5 years, the parent has now kind of really changed their life around. They are in a much different situation and circumstance, and they can petition the court to regain custody of their child with the burden of proof on the parent to demonstrate how their life and their circumstances have changed, thus enabling them to, be a safe option and, safe and steady option to take custody of their child, to regain custody. Now, another permanent option is a Yurok adoption. So this is where parental rights will also not be terminated except in extreme circumstances as determined by the court, but parental rights are greatly reduced, even more so than a guardianship, and a parent cannot petition to regain custody in the same way as with a guardianship. So there is not an opportunity when an adoption has been ordered to come back 5 years later in the example and scenario I shared before. That's kind of the end of it. That is the permanent plan. But the reason why often parental rights are not terminated, however, even though it is a final legal plan, is because there isn't a severing of that relationship to the child's extended family and kind of where they come from. So really one way to think about it is that the extended family of the child adopts in a new set of parents, but it doesn't have to replace, grandparents, aunties, uncles, and other relatives, which is the kind of dynamic in a regular kind of state court adoption where parental rights are terminated. Another permanent planning option is extended foster care, and this allows a youth involved in the dependency system, the child welfare system, who are turning 18 to continue to receive supportive services from ages 18 to 21. So this can be a really beneficial option, especially sometimes, young people turn 18, maybe they're still in high school, maybe they are planning to go on to, college or have another kind of young adult plan. So there are ongoing services and supports that kind of can help them launch into that next phase of young adulthood. All right, concurrent planning. So again, kind of the process of, making plans in the event that reunification is unsuccessful. So parents, after, child has been removed and reunification has been started, there is that case plan that is generated that outlines those specific kind of goals that the parents need to engage and accomplish and work towards in order to, be able to successfully reunify with their children. While the parent or parents are actively engaging in reunification services, there's also a process of concurrent planning happening. So again, that's, what happens if reunification is unsuccessful? What will the permanent plan be for that child or children? And then at the point when we get to kind of the end of that timeline, that, we're either at the point where the court makes that determination that, the parent or parents have done, their part and the child can be returned home, or we move forward with the concurrent plan the other permanency option, which is either going to be the guardianship, the adoption, or long-term extended foster care. So more on concurrent permanency planning. Again, plan A is always reunification. That's always what we're working towards. The department, the parents, the courts, you as the foster parent, we're always working towards and supporting children to reunify with their parent. Now, we know that doesn't always happen. Reunification is not always successful. So that's where we get into the plan B, which is that concurrent planning process. So there must be one of the approved permanency goals in order of preference. Parents are informed of concurrent permanency planning process from day one. So it's a conversation that's already and always happening. In the event that reunification is unsuccessful, which is plan A, what is kind of the plan B? The parents must have an opportunity to provide input on plan B. And plan B is only initiated after the court determines that reunification is no longer the goal. So that it's, plan A has not been successful. So you, as the one providing the care during the time that parents are not able to, you are an integral part of not only the plan A, but plan B. So supporting reunification, but also, perhaps being the plan B in the longer term. Here you can see before you the Yurok placement preferences. So on the left here, these are the foster care placement preferences. So the top, preference when children have to be removed from their biological parents is always going to be with a member of the extended family. That's always what the department is working towards as its number one priority, is placing children with family. And family, we know, is defined very broadly. So those are, your extended, family members, no matter how distant they may be. Family is family. And then if family is unavailable after an exhaustive search, another foster home approved by the tribe, and so forth down the list. Also adoptive placements. So that's kind of where we get into the plan B. While the code doesn't specify, generally an adoptive placement preference is also with a member of extended family. And then on down the list, other members of the child's tribe or other Indian families. Placements, always should be in settings, or children should always be put in settings that are least restrictive, that are most like family, that are within reasonable proximity to the child's family, especially for purposes of visitation. And then also placements that that are able to meet any special needs that the child may have. So defining permanency and permanency planning, we really appreciate this quote, which states, "Permanency is not a philosophical process, a plan, or a foster care placement, nor is it intended to be a family relationship that only lasts until the child turns 18. Permanence should bring physical, legal, and emotional safety and security within the context of a family relationship and allow multiple relationships with a variety of caring adults." So that is to say that we are always collectively working towards creating the most robust system of support for our young people that lasts beyond the age of 18, strengthening those connections, strengthening those relationships, because the more people that love and support children, the better. So how do we kind of bring everybody in closer and maintain those relationships rather than, severing those types of ties and relationships? All right, so what are the responsibilities of tribal social workers in all of this? When a child comes into Yurok care, the tribal social workers are responsible to ensure the following. They're responsible to ensure that educational needs are met, medical, dental, developmental, and behavioral health needs are met. They ensure children build and maintain connections with family and other important people. They ensure children have skills and abilities to transition out of foster care when they are older. So kind of preparing them for next steps out of childhood and out of foster care. The tribal social worker visits the child in the home at least once per month to check on how everybody's doing, address any needs, celebrate any victories. The tribal social worker ensures children can participate in their culture and other extracurricular activities. Many of these items are contained in a case plan, which is reviewed and approved by the court. So case planning, we've mentioned that, I've mentioned that multiple times. Really, what is that and what does that mean and what does that look like? So a case plan is developed by the family team. So that's inclusive of the tribal social worker, the parent or parents, the child if they are of applicable age, and any other formal or informal supports. So that could be family members, that could be other service providers, whoever is a part of that family's team and linked in with the family. And then they develop goals, which go into the case plan. Goals address safety, which will include safety planning goals to return safely to family, and also goals to support the foster parent. So ensuring that you have the tools and resources you need to support the child in your care. Goals address permanency, so that includes the concurrent plan. In the event we need to launch Plan B, what does that look like? And goals support well-being, which include goals that connect the child to and family to culture and the tribe and tribal community. Case plan assessment. So the tribal social worker will need to get to know the family and team, the family's team, in the following ways in what is called an assessment. So the tribal social worker must review historical documents regarding the family. So if there is an existing kind of historical record of their involvement in the child welfare system or other historical documents that may be available. They conduct a home visit to assess the home. They observe the children. They meet the parents individually or in a family meeting. And they communicate with existing formal supports and informal supports. So formal supports are going to be other providers. Maybe that is a TANF caseworker. Maybe that is a behavioral health clinician. Maybe it's a representative from the educational program or Head Start, whoever has been regularly and actively interfacing with the child and family, as well as informal support. So those are relatives, friends, neighbors, who is like involved and linked in with this family in kind of that normal kind of family life type of way. Who are this family's people? This ensures the tribal social worker and team can develop a plan that is individualized to the family to meet, their strengths, their challenges, and who they are as unique individual family systems. And then the case plan for parents and families. The following areas will be assessed and services provided accordingly. So again, depending on, what comes out of the assessment, what is determined to be safety challenges and needs. It could be anything ranging from alcohol and drug services, domestic violence, mental health, developmental disability supports and services, parenting support, medical and dental services, vocational rehab services and supports, employment, training, and other educational services and supports, housing, transportation, financial assistance, parental involvement, visitation. And then the case plan for the child. So similarly, an assessment has been conducted of the child to determine kind of what some of their needs are and services that will be most appropriate to meet those needs. It could be enrollment, so actually moving forward with the enrollment process to get the child enrolled. There may need to be a necessity to do a paternity test, other medical, dental and vision services and needs, transportation, clothing, educational supports, culturally based goals. If alcohol and drug use by the use is an issue, that would be addressed, as well as their mental health needs, developmental disabilities, if that is applicable, social and recreational activities, any special requests by the youth based on their wants and desires, missing child reports, physical and sexual abuse disclosures, and delinquency while in foster care. These are all of, a variety of things, depending on what is applicable to an individual child, that will be assessed, addressed, and built in to case plan goals and matched with the appropriate services and supports. Case plan timelines. So the initial plan is, basically executed within 60 days of the child being removed or the case being open. So there must be a case plan in place within the, that 60-day timeline. It is then reviewed at least every 90 days to basically determine, progress, as well as any barriers that have been identified or arisen in meeting the case plan goals or, progressing towards the goals. It is and can be revised every 6 months or as needed. Things change, circumstances change. So sometimes it is necessary to revise. And it will be filed with the court at least 5 days before a hearing. So that way all parties have adequate time to be able to receive that information and be prepared prior to coming to court for a hearing. What is required in a case plan? So the case plan must include the following. So timelines, that was something that was touched on in the episode that we watched, the timelines. And that is a requirement to be addressed in the plan itself. So how long, does a family have to complete, whatever the goal is? A description of services provided to the parents, child, and foster parent, how the progress will be measured and by whom, oftentimes, a visitation plan for the parents. And sometimes this is also inclusive of relatives. So maybe there's a visitation plan for grandparents or other folks who are really close to the child that we want to maintain and nurture those relationships and contacts. There needs to be a description of the type of home where the child is placed. So, is it a relative placement, for example? And a discussion of the appropriateness of the services that have been provided to the child under the plan. So a clear linkage of like why those services are, a part of the case plan. There has to be some kind of linkage to what happened in the family system or what this particular need is in that child. So to make kind of sense of why that particular service is being ordered. All right, case plans, a roadmap to well-being. So plan A, what can we do to reunify? Again, we've talked about those types of services that will be potentially appropriate to help support reunification. And then plan B, what's our backup plan? So similarly, we've talked about the different forms of permanency and that plan B backup plan. Important to note that the plan may include guardianship or adoption by a relative with expectations to maintain cultural and family connections. So again, nurturing those biological family and extended family connections, as well as a clear demonstration of how that child will remain or continue to be connected to, their tribal culture and tribal community. Court representation. Children that come before the court under the jurisdiction of the Yurok Children's Code will be appointed an advocate by the court. Really important that they have somebody kind of in their corner helping to explain things or, helping to kind of translate the busyness of, the court language into, ways that families can really just understand and digest and have time to do so. Parents may represent themselves or be represented by an attorney, spokesperson, or tribal advocate admitted to the Yurok Tribal Bar. Foster parents will not be represented unless the court deems them a party to the case. So good question to potentially ask if you find yourself in that situation. Who can attend court? Court hearings on child welfare matters are not open to the public, right? These are very sensitive, highly confidential matters when dealing with children and, what brought them into the system. The judge may allow other people to be at the hearing if requested by the child or requested by a parent and the child agrees. These people may include family, friends, or other people with a direct and legitimate interest in that particular case or the work of the court. So the court and you as the foster parents. Notice of the hearing and the right to be heard shall also be provided to the foster parents providing care for the child in all status review and all permanency hearings at a minimum. So you'll know when these things are happening. Note that this does not include the detention, the juris, or the dispositional hearings. Those are the hearings that happen at the very beginning. So those things might have happened already before a child even comes into your care. Notice of and right to be heard does not require the court to make the caregiver a party to the proceeding. Caregivers will not receive copies of petitions or court reports.